Hello, my name is Janan Jarrah. I'm one of the lawyers here at eLaw Alliance, a law firm located in Edmonton, Alberta, Canada. Today's legal video is going to cover the topic of child welfare law in Alberta. The statute or act that governs this area of law in Alberta is called the Child, Youth, Family and Enhancement Act, and it can be obtained online for free using the CanLE legal database. It's a free legal database. You just have to search out Child, Youth, Family Enhancement Act and you'll get a free copy of that act, and it's pretty comprehensive and lays out all of those rules related to this area of law. CanLE is also a free legal database, so it is open for anybody to use it to search out statutes across Canada. So another thing to keep in mind about child welfare law in Alberta is that there are a number of different agencies, government agencies that handle child welfare matters. There are too many to name across Alberta, so I'm going to refer to them collectively as CFS or Child and Family Services for the purposes of this video. Now, when CFS or Child and Family Services or the police get a complaint related to a child in need, they have the option to pursue the matter outside of the court system or within the court system. And before I explain those two options, let me first let you know what it means when a child is in need of intervention. And that's going to be found directly in the Child, Youth, Family Enhancement Act. It indicates that a child is in need of intervention if there are reasonable and probable grounds to believe that the safety, security, or development of the child is in any way endangered, and the specific ways a child may be in need of intervention or be endangered are the following. If the child has been abandoned or lost, if the guardian of the child is deceased and there is no other guardian, if the child has been neglected by the guardian, if the child has been or there is substantial risk that the child will be physically injured or sexually abused by the guardian, if the guardian of the child is unable or unwilling to protect the child from physical injury or sexual abuse, if the child has been emotionally injured by the guardian, or if the guardian is unable or unwilling to protect the child from emotional injury, or if the guardian of the child has subjected the child to or is unable or unwilling to protect the child from cruel and unusual punishment. In any one of these scenarios, a person is obligated to report the situation to the police or Child and Family Services. Now, once Child and Family Services obtains a complaint, they are permitted and have very broad powers to investigate that complaint. So they can definitely talk to the parents or guardians, third parties, and as part of their investigation, it can encompass quite a few people, including being able to come into your home to question you or to make sure a child is okay. Once a child is determined to be in need of intervention, Child and Family Services has the option to pursue matters outside of the courts, meaning they can enter into agreements with the parents or guardians related to how to address some of the concerns that were raised as a result of the report. These types of agreements are supposed to be voluntary. Parents are not forced to enter into them, and it's normally a good idea to get a lawyer to provide legal advice about the implications of signing off on such agreements before the agreements are signed off on. And the agreements themselves are called either custody agreements, family enhancement agreements, or more seriously, permanent guardianship agreements. So if you as a guardian or parent are given this option to sign this agreement, get a lawyer to review it with you first. There are a number of lawyers in the city and across Alberta, including our firm, that will provide free legal advice or free legal information. So seek out those supports before you sign off on these agreements. And the reason is because you want to be 100% sure what you're signing off on and what the implications are. You want to be fully informed, and do not rely on CFS necessarily to provide you that information. They're not independent. They don't work for the parents, whereas lawyers are independent of CFS and they can give you that independent legal advice. Now, if CFS decides to take the route of going through the court system instead of through these types of agreements, Then normally what they'll do is apply for something called an apprehension order. They can apply for these orders in court. Oftentimes they're granted by a judge, and it enables CFS to go into someone's premises and literally take the children away, apprehend them. It doesn't have to be given to the parents, notice given prior to the application. In fact, notice to the parents is oftentimes given after the apprehension order is already granted. But certainly after the apprehension order is granted, parents definitely need to be given notice so that they can properly respond to it. Once an apprehension order is granted, CFS has a number of specific days, they don't have forever, but a number of specific days to then decide what type of substantive application they want to make. And under SIFIA, there are 3 types of court orders or applications that CFS can make. And before I get to that, let's talk a little bit about what initial custody is. Initial custody follows an apprehension order. It's an opportunity for the parents and CFS to argue to a judge why temporary custody should be granted. Now, the parents can fight and say, well, we want temporary custody until the substantive matter is resolved. CFS could argue, we want temporary custody or initial custody until the matters are fully resolved. Because it can take a number of months or even over a year before the matter is finally resolved. So in the meantime, the court has to decide who should have custody of the kids in that meantime period, and that's called initial custody. Normally it's 42 days from the date of apprehension that it has to be decided. Parents have the option of consenting to it or opposing it. If they oppose it, then a hearing will be heard in front of a judge. CFS will present their evidence, the parents will present theirs, and then the judge will make the decision based on what he or she thinks is in the best interest of the children. If initial custody is granted or consented to, then normally the next step is dealing with the more substantive application. CFS has the option of applying for 3 separate types of orders, and I'll go through each one in a little bit of detail. But just to name them, one is called a supervision order, another is called a temporary guardianship order or TGO, and another is called a permanent guardianship or PGO. Supervision orders and TGOs can vary in duration. I've seen them be as short as 3 months or as long as 6 months. Normally, a supervision order or a temporary guardianship order will lay out a series of conditions that CFS expects the parents to comply. And in fact, if it's in the terms of the supervision order or temporary guardianship order, the parents are obliged to follow through with those conditions. The types of conditions that can be included in a supervision order or a temporary guardianship order may be that the parents take parenting courses, psychological counseling related to addictions or domestic violence. Sometimes these orders require or request assessments be done on the parents, like parenting and psychological assessments or neurological assessments. The difference between a supervision order and a temporary guardianship order is that in a supervision order, the children remain in the parents' care while those conditions are being met. Whereas in a temporary guardianship order, the children are placed in the care of either other family members in kinship care or in foster care. They're not with the parents while those conditions are being met. So a supervision order is less intrusive than a temporary guardianship order. Once a supervision order or temporary guardianship order have expired, CFS has the option to then just end the matter there and say, okay, you guys have met your expectations as guardians and parents. We are now going to back away from the situation. Or if CFS finds that the parents or guardians have not met those expectations to their satisfaction, CFS has the option to apply for another court order, whether it be another supervision order, another temporary guardianship order, or even a permanent guardianship order. If the situation is serious enough, CFS has the authority to apply for a permanent guardianship order right off the bat. A permanent guardianship order is a very serious type of application made by CFS. It's a very serious type of order. Essentially what it is it strips away a parent's parental rights almost completely. Sometimes parents have a little bit of access after a permanent guardianship order, but not always. It really is the termination of a parent's rights completely. So it's a very serious application, and you should think twice before agreeing to it if you are faced with that sort of situation. My advice would be, if you are faced with a permanent guardianship order, you should definitely get legal representation to help you, whether it is to advocate for you and oppose it altogether, or to negotiate post-PGO access. You should get an independent lawyer to help you out with any one of those 3 types of applications, but most especially if it's a permanent guardianship order. Something to keep in mind with CFS is that there are maximum allowable days in care. This is under Section 33 of SIFIA. Basically, it lays out that depending on the child's age, whether they're 6 and under or over 6 years of age, they put caps on days in care, meaning if the child reaches that maximum, Child and Family Services are obligated by the law to pursue permanent guardianship after that. So once kids max out days in care, Child and Family Services are obligated by law. They have no choice but to then go for permanent guardianship. Of course, what this means is that parents need to be mindful of how many days in care their children have accumulated, because it could have some very serious implications. Now, with all 3 types of applications, a parent has the option of consenting, negotiating better terms, or opposing it altogether. And when they oppose it altogether, trial dates are set, normally months or sometimes over a year down the road. And once the file finally reaches trial, the judge will hear all of the evidence from CFS, all of the evidence that the parents present, and then make a decision based on what he or she thinks is in the best interest of the child about whether or not that child should, whether or not any one of those 3 applications should be granted. With a TGO and a supervision order, there is basically an indication from CFS that they have confidence the parents can comply, and so they pursue it with hopes that the parents can complete those specified conditions. But with the permanent guardianship application, it's basically a message from CFS that they don't have any confidence that the parents can complete those conditions. So suffice to say, if you're dealing with any one of those 3 types of applications, but especially permanent guardianship, get legal assistance from a lawyer. You can contact legal aid to assist you with setting yourself up with a lawyer, or you can contact a private lawyer for that purpose. Another few things to keep in mind. I normally tell clients that I advocate for, parents or guardians, that until we get to trial, I'd like them to, as much as possible, cooperate and do what Children's Services is asking. Because it'll only help, in my opinion, once you get to trial, you'll be able to tell the judge, I completed my counseling, my courses, and that can help your lawyer advocate for you at the trial. And in some cases, if the parents really step it up, Children's Services will withdraw their application prior to the trial. So I always encourage clients to work as much as possible with CFS prior to the trial. Once you get to trial, then of course it's no holds barred, it's a battle, and that should be confined within the 4 walls of the courtroom. Meaning, I don't suggest parents be extremely defensive or argumentative with CFS outside of the trial. They should be cooperative and work as much as possible on proving that they are in fact adequate parents. It's only going to help your lawyer anyhow to be able to say by the time you get to trial that all of those conditions have been met. So work hard on those conditions. Leave that battle for within the 4 walls of the courtroom. Another thing to keep in mind with Child and Family Services is that if you are a parent or guardian of an Indigenous or Métis or Inuit child, there are special considerations in SIFIA for children in those communities. This is an obligation. There is no choice. You must take into consideration certain cultural policies and practices when dealing with children from those communities, Indigenous, Métis, and Inuit. And if CFS is not taking those cultural practices or policies in consideration, then that is something they're going to have to address with the judge. It's not permitted. In fact, they're obligated when dealing with children from those communities to take into consideration the unique history and cultural practices of children in those communities and try to preserve those cultural practices and that history. Another thing to keep in mind is that once a child reaches the age of 12, the court will start to consider what they may have to say about things. They are even provided notice of applications once they reach 12 years of age. It's not uncommon, in fact, it's very common to have children who are in the child welfare system and going through the courts to have their own lawyers. So they'll be assigned their own lawyer to speak to the issue and to either advocate for them or speak to what they think is in the best interests of the child. So I can go on and on about child and family services and the laws related to this area. So suffice to say, this video is just intended for some general information. If you want more detailed information, then certainly you can call us directly and we'll provide that. So thank you for joining in. Until the next time.